Now call the first case on this morning's docket. That is case number 103083, State of Kansas v. Matthew Astorga.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Matthew Astorga. I would request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, I know that this court has already started talking about the issue before the court regarding the constitutionality of the Kansas Hard 50 sentencing provisions and maybe what to do about those provisions in light of the special session this past fall. But I don't know where you're at in talking about that. So I'm going to start at the beginning and expect that the court will jump to wherever you want to talk about today. The first question is whether or not the Hard 50 sentence imposed against Mr. Astorga is unconstitutional after the United States Supreme Court's decision in Alene this June. And, Your Honor, we think that's a fairly easy question. Alene decided that mandatory minimum sentences have to be, the facts that support mandatory minimum sentences have to be proved to a jury beyond a reasonable doubt. This court, at the state's urging, had previously held that the Hard 50 sentencing scheme is a mandatory minimum sentence, and in fact it is. And so it seems pretty straightforward that the Hard 50 sentence in this case, imposed in this case, is unconstitutional.
Mr. Hodgkinson, I'm thinking that it's not quite as easy as you're making it out to be, or as you made it out to be, I believe, in the brief that you filed in this case. We still have, after Alene, we still have the exception, as far as I can see, for Almondes-Torres and the fact of a prior conviction. You don't address that in your brief, but maybe you could address it at this point.
Well,
and that's an issue I should point out in this case, because it was the fact of a prior conviction for second-degree murder that provided one of the aggravating factors that the judge relied on.
Sure. And so I have two responses to that, and I didn't spend a lot of time briefing that because we didn't contest, as this court found in the original decision, we didn't contest the prior conviction exception in the original appeal, so I felt a little bit hamstrung on that. There are two responses to it, though. First of all, it is slightly distinguishable because the state didn't raise that issue. This was actually, that prior conviction was raised, I believe, by the court at sentencing. And so to the extent now that Alene has come in and said that these are essentially elements that have to be charged or at least alleged by the state, that particular fact was never alleged by the state. It was brought up sua sponte by the court. So that might be a little bit of a distinguishing factor.
At the actual sentencing, you're saying?
At sentencing, yes.
But wasn't there evidence? I mean, wasn't there a journal entry from New Mexico about the prior conviction? So how did that get into the record?
I don't remember as far as proof. I suspect that's right. I don't remember as far as proof, but I just remember as I reviewed it, actually getting ready for this brief, thinking that one distinction could be that it wasn't. It was brought up by the court, not by the state. That wasn't, we didn't object to that in the original appeal. So that's a part of why I didn't spend a lot of time on it, but I wanted to answer the Justice's question.
To your recollection, was that the only evidence, the New Mexico journal entry?
I don't even have that recollection. I won't even claim that, Justice Johnson.
Well, to me it's pretty important because the Hard 50 does not say a prior conviction for murder. It says prior conviction for a felony in which the defendant inflicted great bodily harm, dismemberment, disfigurement, or death. And we've got a case on this morning's docket in which the defendant was convicted of premeditated first-degree murder for having driven the vehicle next to a rival gang member's car so the passenger could kill him. And that journal entry doesn't say that the theory was aiding and abetting, so we don't know from the journal entry whether it was a principal or an aider or abetter. And arguably, if the defendant didn't inflict the death, that aggravator doesn't apply.
I think that that could be an issue, and in fact, I've talked about the prior conviction exception, and we've talked about this in other cases, in other contexts. To the extent that the prior conviction still is good law, and it is good law as of today, there's no U.S. Supreme Court case overruling Almendarez-Torres, some that shows that they should, but they haven't. But they have limited the Almendarez-Torres to the fact of a prior conviction, not facts about prior convictions. And that's certainly true, and that's as true as recently as June 2013 from the United States Supreme Court. So to the extent that the record does not include evidence and cannot include evidence of facts about the prior conviction, that could be a problem. That could be a problem.
I want to take you back to your first response where you said it was distinguishable because the state didn't raise it. Are you saying that if the state is relying upon one aggravator, that the district court cannot sui sponte rely on another aggravator?
Yes.
Is that okay? I'm just clarifying your argument.
I believe it's improper for the judge to decide what to charge defendants and what elements to allege against defendants. So, yes.
And that's based on the lien says that those are functional equivalent of elements, and the court is finding an element of that was not charged or alleged.
The court alleged an element, yes.
Okay.
Even if it's an element that's not required to be proved to a jury beyond reasonable doubt. The last part of my response to you, Justice, is even if I'm completely wrong about all that, there's still a finding in this case that was made, and this is the dispute between my colleague and I about whether, because it's not just the finding of the aggravating factor, there's also the finding that no mitigators outweigh those aggravating factors. And there's some dispute between my colleague and I about is that a finding or not, and I would say I again think that's a fairly easy question. If you look at the wording of the statute says it's a finding. It acts like a finding, and in fact, Kansas district courts have no discretion in sentencing at a hard 50 sentencing case. This isn't a situation where you find the aggravating factor and then the judge says, well, I believe you found the aggravating factor, and I even think maybe the aggravating factor outweighs the mitigating factors, but I still have discretion to give you something less than that. That's not the way our statute works. In fact, district courts have no discretion at a hard 50 sentencing proceeding under the statute that Mr. Astorga was sentenced under. It's if you find that the aggravators are not outweighed by the mitigators, hard 50, period. And if it's not that finding, it's a negative finding, it's a hard 25, period. It's either or. There's no discretion for judges in this.
Well, can I interrupt you there because I want to talk about that word finding because you keep using it as though it's all a fact finding, and yet the statute in the prior paragraph talks about the court may be presented evidence concerning the aggravating and mitigating factors. And then it seems to anticipate a second step where the court has heard the evidence, and then based on that evidence of aggravating and mitigating factors, it does this weighing and balancing. So you're kind of mixing two concepts that I think the statute separates.
I respectfully don't think I'm mixing them. I think the statute says it's two findings. And you know what the best evidence of this is? We know because the legislature this year in the special session passed a law that they said was it's supposed to be exactly the same. And who makes the finding in their amended law regarding the weighing? It's the jury. The jury makes that finding, and then does the judge have any discretion about what sentence to give a person under their amended statute? And the answer is no. Why? Because it's a finding. The jury, under their amended law, makes that finding regarding whether the aggravators are outweighed by mitigators.
Same as in death penalty litigation.
Mr. Hodgson, what is meant in a lien? It's one of the areas that talks about judicial discretion. Says, our ruling today does not mean that any fact that influences judicial discretion must be found by a jury. We have long recognized that broad sentencing discretion informed by judicial fact-finding does not violate the Sixth Amendment. My question is, where does judicial discretion come into play in a sentencing if we follow your interpretation? It seems like there's really none, if that's the case.
It's our position, and I believe the plain reading of the statute, that the legislature took away discretion from district judges in these hard 50 cases. They could have said, here are a bunch of aggravating factors, here are a bunch of mitigating factors. District court, you consider all of these and decide. You can decide, do you want to give them a hard 50 or a hard 25 or something else?
Once
that would
the
have been
jury's found them to exist.
But under our statute, once the jury finds the aggravators and finds that the aggravators outweigh the mitigators,
You have,
I don't think the district court, under our statute, has any discretion left. That's a decision that the legislature made.
And under the old statute, the judge had discretion in the weighing process. We would not overturn the weighing of aggravators versus mitigators unless we found an abuse of discretion, but the court did not have discretion to find aggravators, no mitigators, and still give a hard 25, is what you're saying.
No, I wouldn't say that the judge had discretion to weigh. I mean, the judge is making a finding in that regard. You have discussed it, as my colleague has noted, reviewing it for abuse of discretion, but I don't really think that that's what the judge is doing at that point. The judge is making an evaluation of the evidence. You can call it whatever you call it, and you can review it by whatever standard you want to review it. But particularly, like I say, if you look at the amended statute, we know it's a finding. And once the judge does that, you could review it for substantial competent evidence or whatever you want to review it for. But I don't think the judge has discretion to weigh things. Judges are put on the spot in the old law to make that. Now juries are put on the spot to make that finding.
Where do the mitigating circumstances come into play? This is one where it's sort of teed up because defendant was saying, hey, this was sort of kind of like self-defense because I'd been harassed and I'd been threatened and that sort of thing, and that's a mitigating circumstance is what this victim had done to me beforehand. Well, doesn't someone have to decide if that's really true?
Yeah.
And isn't that a factual finding by the judge?
It could be a factual finding.
Well, I mean, it's sort of, we keep talking about making the findings on aggravators and then doing the weighing, but it seems to me that you have to find the aggravators, find which mitigators
Okay.
are supported by the evidence before you do the weighing, and no one's talked about the mitigating circumstances, who makes those findings, and where they fit into the calculus with regard to a lien.
Sure. Under the previous law, a judge was making those findings too. A judge made all the findings regarding aggravators and mitigators under the law under which Mr. Astorga was sentenced. Under the new law, all of that evidence has to be presented to a jury because the jury has to make those findings regarding whether the mitigators are present by I don't know what standard, and whether aggravators are present beyond a reasonable doubt, and whether beyond a reason, this is their statute that the legislature just passed, whether beyond a reasonable doubt, whatever those aggravators are that you found outweigh whatever mitigators there are.
I'm looking at this case with the old law first, and a lien did not do away with Apprendi's prior conviction.
It did not.
But assume that it doesn't matter what the facts, that a second degree fits that aggravator. Doesn't there still have to be fact finding by the sentencing judge? Is what I'm getting at is even with the prior conviction, the court has to decide if there are any mitigators before the weighing takes place.
Yeah, I mean, there has to be evidence of mitigators. Because we think under the statute as it was before and as explained by the legislature at the special session, that weighing as described in our statute is a kind of finding. It has to be found beyond a reasonable doubt and should have been found beyond a reasonable doubt by a jury. Because of that, regardless of the prior conviction exception, it's our position that this case is very similar to the cases that came down under Apprendi, that the hard 50 scheme as it existed at Mr. Astorga's sentencing is unconstitutional on its face. It cannot be constitutionally applied because there was no mechanism for a jury to make those decisions about all of the facts beyond a reasonable doubt. And in the absence of that, there is no mechanism to sentence Mr. Astorga to a hard 50.
This can never be applied constitutionally. That's an on-its-face argument.
Yes.
To any defendant.
To any defendant. Because it would call upon every court to do this, at least this weighing, which the legislature has said should have been done by a jury beyond a reasonable doubt.
But your on-its-face argument hangs on that, on us agreeing with you that that's a finding. Correct?
Yeah.
Okay.
Could I ask you to address, and I don't think you did in your brief, but there's a number of cases in the death penalty context from various federal circuits as well as state courts addressing that very issue, whether there's a distinction between the weighing process and the findings of fact. And a large number of courts have come out against your position. Have you reviewed any of those cases? I don't think you cite them in your brief, but
I mean,
why doesn't the analysis that they use apply equally in this setting?
there's two things, and I didn't focus on them a lot. I focused on Kansas law and our Kansas statute. And by its own terms, the Kansas statute describes these as findings. The Kansas statute makes no distinction
I understand
between
that,
the finding of the existence of the aggravating factor and the outweighing. So just plain language of
Let's
statute,
assume
first of all.
that we just agreed with that. Assume that, and then let's talk about those cases and whether there's a distinction to be made there.
Okay. I haven't reviewed them a lot, but the distinction, I do not agree that there's any distinction because the idea that there's discretion for judges in these cases is belied by the language of the statute itself. If you had a situation where judges actually did have discretion to decide either some spectrum or even between the hard 50 and hard 25, then this idea that they're doing some weighing that isn't actually finding makes sense. But where the legislature says it's either a hard 50 or a hard 25, and here's how you make that decision.
Okay. Well, I think I'm misspeaking. I think, the cases that I'm thinking of, and since I don't want to talk about specific ones because I don't know if you're familiar, but I think there's a Nevada case that went through all the various courts. And for instance, they discuss the definition of the word facts and talk about what fact finding is. And I think that's where you and I maybe aren't connecting here because I think you're not distinguishing between fact finding and the weighing process. Regardless of the end result of whether there's discretion or not, there's a weighing process that arguably doesn't constitute fact finding.
Yeah, I just don't think it's a distinction that makes any difference. I disagree with those courts, this idea that that's not a determination of the relative importance of these facts. And the determination of the relative importance of the facts is in itself a factual determination.
Right.
That doesn't make sense to me. And in any case, like I say, the best evidence that that's not the way our statute works is the amended statute passed by the legislature in the special session, Your Honor. Because that's not the way the amended statute that they purport to be the same is working in the future, right?
The amended statute was a response to a lien. The amended statute wasn't necessarily, was it some statement about what their prior intent was?
No, it was exactly that. They exactly said, we intend for this to be exactly the same thing,
Okay.
except with the jury doing it instead of a judge, in order to try to make it be able to be applied retroactively.
So we can use that as as a statement of intent.
It's exactly what they said it was. I'm out of time, Your Honor. I didn't get to talk about retroactivity.
Well, you'll be back.
Thank you, Your Honor.
Do we have any further questions of counsel? Thank you, counsel.
May it please the court, Chris Elslager, appearing on behalf of the state. And as I set forth in the brief, my argument for you today has essentially three prongs. The first being that even after Elaine, the hard 50, as it was written and applied in Mr. Astorga's case, is constitutional because the weighing process in the Hard 50 statute is inherently discretionary, and so the Hard 50 provides that guided discretion that the Elaine court recognized as constitutionally permissible. Second, even if
And the discretion is in the weighing, obviously, because once the weighing's done, it's over.
yes, it's in the weighing. I
The
mean,
weighing, it all hangs on the weighing.
and the discretion. I mean, the weighing is entirely discretionary. I mean, it's not a matter of finding any facts. It's a matter of taking the facts that have already been found and balancing those facts.
If there's an aggravator
Yes.
and there's no mitigators, then the court still has the discretion to give the hard 25?
Well, if there's an aggravator and no mitigating evidence has been presented, that makes the balancing very easy for the court, but it's still a discretionary act in balancing.
So
Now,
where in the statute does it permit the district judge to say, I find that the aggravator of the prior conviction exists, there's been no proffered mitigating circumstances, I find that there are no mitigating circumstances, but I'm going to impose the hard 25?
Because here, as a practical matter, if the sentencing court does not want to impose the hard 50, if the sentencing judge feels like it's just not appropriate, the sentencing judge can find mitigating factors, and he can simply say they outweigh the aggravating factor.
That wasn't my hypothetical. My hypothetical is the court finds no mitigating circumstances.
And I would say that's a judge that has looking at the totality of the case, has decided that the hard 50 is appropriate. Because even if the defendant doesn't come forward with any mitigating circumstances, I think the judge could find some if he wanted to. I mean, it's inherently discretionary. It is up to the judge to decide. If he doesn't want to give the hard 50,
So you're saying it's
that.
discretionary for a district judge to make up mitigating circumstances for which no evidence was presented?
not make them up, but they're certainly within the totality of the facts presented in the case. I suppose if you had a case where there was just, I don't know, no evidence presented on behalf of the defendant, I suppose you'd have the hypothetical.
How is that not judicial fact-finding?
Well, I think the judge can make findings of fact with respect to the mitigators. The mitigators don't increase the punishment. What Elaine and Apprendi say is anything that increases the punishment must be found by the jury. Says nothing about mitigating circumstances that could reduce the punishment. There's nothing in those decisions that say that it would be unconstitutional for the judge to find on his own sua sponte mitigating circumstances. So anyway, getting back, the weighing process itself is not a fact-finding process. As I think it was the Nevada case, I've got a quote from the weighing determination does not involve any findings of fact. It simply requires the balancing of facts that have already been found. And as laid out in the brief, there's a whole number of courts that have looked at the weighing equation and found that it's an act of discretion. It's not a finding of fact. This court has always...
Why does the new law make it a finding of fact for the jury?
Well, I don't think you should read into the new law what my opposing counsel is suggesting. In rewriting the law and after Elaine, there was a lot of discussion about what the new law should look like.
Is that part of the new law supposed to be exactly like the old law, except for changing the party who's doing the weighing? Is that the intention of the legislature?
And here's why. It's a matter of over-delivering going beyond what the Constitution requires. Because there certainly was discussion among the prosecutors and legislators that, hey, the Constitution only
Is
requires...
that in the record?
Well, no, but I think my counsel our opposing counsel has opened the door to this issue by making a suggestion about what that means.
Well, let me just ask this: is there any legislative history cited to us by either side in this case?
I don't believe there's any legislative history cited by either side.
Okay.
But simply because the weighing equation was, everywhere in the old law where it said the judge or the trial court will find was changed to jury, it's not. You shouldn't read too much into that.
But we do know in the new law, without legislative history, we do know that the weighing of aggravators and mitigators is done by the jury.
Yes.
And we do know as a general proposition that juries are fact finders and judges are handle the legal questions.
Yes.
So, but you're saying notwithstanding that it's a jury question, it nevertheless is a legal question.
Well, I'm not saying it's a legal question. It's a discretion. It's an act of discretion. You can look to the death penalty jurisprudence for that, because even though juries find facts, but in the death penalty context, they do the weighing, and that has always been referred to as guided discretion. It has not been ever referred to as a finding of
The
fact.
big distinction is that the death penalty scenario allows the judge to disregard the jury's death penalty finding. The judge can impose life without parole, notwithstanding the jury's. Is that possible here?
Not in the hard 50.
And it
Not
wasn't in
with
the
new
old law.
statute.
In the old law, it says shall. If the aggravators are not outweighed by the mitigators, the court shall.
But in the old law, the judge was making that discretionary determination. And I think it is important when you look at the standard of review, although counsel says it's not. If it was a factual finding, this court would review that finding for substantial competent evidence to support it. But this court has always reviewed those determinations under an abuse of discretion standard, which would seem to imply that it is a discretionary act. But even if you were to disagree with me on that, I think that his facial challenge to the constitutionality of hard 50 has to fail, because for a facial challenge to succeed, the law has to be capable of there should be no set of circumstances under which it would be valid, and that's just not the case here. As we pointed out in the brief, and certainly in this case with the prior conviction exception to Elaine and Apprendi, it can still be applied constitutionally, and as in this case, it was applied constitutionally.
Was that your third response?
Well, my third, the third prong of the argument goes to the retroactivity of the new law when if we get that far.
Okay. While we're here, though, the aggravating circumstance is not a prior conviction for murder. In fact, it says, quote, a felony in which the defendant inflicted great bodily harm, disfigurement, dismemberment, or death on another, end quote. And so the fact that you have a journal entry of conviction for second-degree murder, how does that tell us whether the defendant was the principal or an aider or abettor?
I think it tells you that the defendant has been convicted of a felony involving the death of another person.
But that isn't what it says here. It says, in which the defendant inflicted. It doesn't say in which the defendant was criminally responsible for, or in which a person was killed, or like the felony murder, death in the commission of, flight from, or whatever. It says the defendant inflicted. Under the rule of lenity, I don't know how you read that any other way than the defendant has to be the shooter or the stabber or the killer.
Well, to me, I think if someone has a conviction for murder, the obvious implication is that they did it, that they were the shooter, they were the one who committed the murder. And if for some reason, if that wasn't the case, if he was just an aider and abettor, then I think it would be incumbent on the defendant to bring that up. I don't know that that's ever been.
And if they bring that up, what happens?
Well, then I think you have to have a finding of fact.
And then you have judicial fact finding. So the journal entry per se is what I'm getting at, is the fact of a prior conviction is an exception. But the fact of the prior conviction doesn't fit necessarily within that description of the aggravating circumstance. You have to make the additional finding that the defendant was the principal actor.
Perhaps. I think that's really parsing the language in the statute. But
that's really construing the statutes in favor of the accused, like the rule of lenity tells us.
You and I are going to disagree on how far that goes. I mean, I think when somebody's got a conviction for second-degree murder, that's pretty strong evidence that that person has committed a felony in which he caused the death of another person.
Let's start at the bottom, though, of this and then work our way up, because you guys have started by working it up. You would agree that there are going to be prior convictions that on their face, the elements of that conviction don't fit the statute for the aggravating factors for the hard 50.
Yes.
And so in those instances where there are elements of the offense of the prior conviction that don't fit, like a heinous crime, for example, you wouldn't necessarily know that from some convictions. So you'll agree that at some level, a prior conviction isn't just a pass for the state.
Right, I think, and we laid out in the brief, there's several potential circumstances that I've set forth in the brief where it could meet all the requirements. Everything could fall into place, and the Hard 50 could be applied constitutionally in those circumstances. But there's a whole lot of other circumstances where it's not going to work. But the point being that because it can be applied in some circumstances in a constitutional manner, it's not unconstitutional on its face.
Oh, I don't have, yeah, I'm not trying to talk about that. I'm trying now to get into the weeds of applying the law and figuring out whether there's, where we have the lines to draw. Because this is a good case, now taking it to the top, where we have a second-degree murder conviction. So what do we make of that? There's just a second-degree murder conviction. Do we have to say that because of that conviction, the elements of the statute are met on its face?
I believe so.
Okay, do that for me.
Well, the aggravating circumstance is that the defendant has a prior felony conviction in which I think it was great harm, disfigurement, or death was caused. Mm-hmm. Second-degree murder is a killing. I mean, somebody died, and he was convicted of it.
And can you be convicted for second-degree murder if you didn't actually do it?
I suppose you could be convicted on an aiding and abetting type of...
How do we get behind that?
Well, honestly, I don't know.
I mean, why isn't that the same problem as what we just talked about, where an element of the offense doesn't carry the day?
See, I just don't think you need to look that far past the prior conviction. I mean, the prior conviction on its face is what it is. I mean, it's a conviction for killing someone.
Yet you said if the defendant raises the point that I got this second-degree murder conviction because of an aiding and abetting situation, then all bets are off, and now.
Then I think perhaps he's raised an issue that maybe has to be presented to the jury. I don't know with that hypothetical, but I think certainly in this case, if we want to get to this case, I mean, he hasn't even challenged it.
No,
I mean, it's probably, I mean, quite honestly, I don't think the court should even consider it really because he never challenged that aggravating circumstance. So I think that it's really he's really waived that argument. But if we're going to drill down on this, I think it's there are some. My point here is that there are some circumstances where the Hard 50 could be constitutionally applied. For example, if the defendant was charged with killing two people, and that was the aggravator. I mean, he was charged with killing two people, tried for killing two people. The jury convicted him of killing two people, and then that was the aggravating circumstance that was used to give him the Hard 50. That is entirely it's all there. It's a constitutional application. Therefore, the Hard 50 is not unconstitutional on its face. And that's the ultimate point I want to get here, is that it's not unconstitutional on its face. Then I think it's applied to Mr. Astorga, it's not unconstitutional, because I think at face value, that prior conviction of second-degree murder he has fits the aggravator. Moreover, I think he's waived any challenge to it, because as this court noted in the first appeal, he didn't challenge it. So, I mean, that's enough. I mean, so that you didn't even really get to his challenge to the other aggravating circumstance because
we're talking about it right now because you said there's no way in which this could be unconstitutional on its face, and so it's germane to your argument.
Yes, certainly. I mean, and what I submit to you is the hypothetical that I just pointed out, where you have two murders, is another possible constitutional application which prevents this a finding that it's unconstitutional on its face.
What about as applied to him, though?
Well, again, as applied to him, I believe that his prior conviction for second-degree murder on its face fits the aggravator.
Because somebody died, and the difference between inflict and cause doesn't matter.
To me, it doesn't matter. I think that's a distinction without a difference.
Okay. I think I got your argument. Do you want to talk about retroactivity? Because I think you're...
Certainly, we can talk about retroactivity. I mean, clearly...
Can I first ask how that issue's ripe in this case, where no one has yet attempted to impose...
Yeah, I think I forthrightly pointed out in the brief, arguably it is not ripe. What I would submit to you, though, is that it is ripe in the context that you may if you're going to remand the case, it is, I think, certainly within the court's power to give the district court guidance on remand. Certainly, the state would seek the hard 50 again. That's why we went and changed the law, was to and did it in a
But it
special
wouldn't
section.
necessarily get it. That's the problem. The state won't necessarily get what it wants, right? If you apply the new statute or attempt to apply the new statute to this defendant, then you may or may not get what you ask for. So there may not even be another appeal.
Okay, I see what you're saying. So, but
That's what makes it unripe.
right, and you don't have to get to the retroactivity. I mean, there are plenty of other cases in the pipeline where it will arise. Although I know from the standpoint of both the prosecutors and the defense attorneys that we would all like to have guidance as quickly as possible on how to apply this, if it can be applied, and so on. And for that reason, that's I would submit to the court. You have it within your authority to address it. But if you don't want to, I'm not going to push it. I mean, if you want me to just
With respect to the actual retroactivity, I need some help. Aline said that the aggravating factor was the functional equivalent of an element, which carried on from Apprendi, or at least the progeny of Apprendi says, we don't care what you call it, it's an element, right? And Aline said that. And if we're missing an element, when the case comes to us, why don't we have a sufficiency of the evidence problem, and which would preclude do-overs? In other words, if this a first-degree premeditated murder case came to us and the jury had not found premeditation, we couldn't send it back and say do-overs, present the issue of premeditation. In other words, serial findings of elements. We don't allow that. Why do we allow it here if we're talking about an element?
Well, the first thing I would say is that the element's already been found. So if there's a problem here, it's with the procedure, and you send it back for that. Just like in the death penalty case, like in State v. Kleypas, the court found the problem with the procedure and sent it back for a new determination of the aggravators and mitigators, and then whether or not the death penalty is appropriate. The same thing here. You got essentially the same process, only without death at the end you have a hard 50. And also, the U.S. Supreme Court has said even if you fail to present an element of the crime to the jury, that is amenable to harmless error analysis. So it's not just a King's X, you're done. There are options to review the case and to send it back. So. But I think the death penalty context gives you the best analogy there. It's no different, because what you had in Kleypas was this court said, hey, the procedure's wrong. We're going to rewrite the procedure and send it back. What we have here is Elaine, possibly, depending on this court's decision, has called into question the procedure that was used in this case. So if the court finds a problem with the procedure, well, the element was already found. It's not like the element was never found below. The element was found below. It's just the procedure might be the problem, so you just send it back for consideration of the new procedure.
As long as the element's found by some entity, even if it wasn't a constitutional entity. I mean, the problem here is that you have a breach of the Constitution.
But that was the same case.
By the judge having found the fact.
If that's the way, I mean, if you disagree with my opening argument, yes, but that's no different than, say, in the death penalty context, when you have a constitutional error and you send it back, you still, we still get to have the what you call a do-over. We still have another proceeding to determine where to go with the case.
Can we just decide the fact like in Reyna?
I think you could decide in this case that the second-degree murder conviction on its face is sufficient to meet the aggravating circumstance and is sufficient to support the hard 50, just as you did the first go around. Okay. And I really didn't get into the retroactivity, so I get the sense that the court doesn't want to discuss retroactivity. But if there are any questions, I will stand here for the next second.
Have any further questions of counsel? Would you like 30 full seconds to wrap up?
I think I've made my points here, and as I've said, I think that if you look at the weighing equation itself as a discretionary act. It is not a finding of fact, and that provides the guided discretion that the Elaine court was talking about when it said that some judicial fact finding is constitutional. If it guides the discretion within the range, the prescribed range, and the hard 50 is within the prescribed range of 25 to life. And as applied to this case, as I've already stated, I think the second-degree murder conviction on its face is sufficient to provide the aggravating circumstance to support Mr. Astorga's hard 50, and I think you should affirm.
Sure.
If you're saying that's discretionary, it seems to me that there's a distinction between the facts of Elaine or Aline. In fact, the dissent there said, well, he could have done the 7 years. Here, you didn't have, you either had the hard 50 or had the hard 25. Do you see a distinction in the statutory scheme in Elaine, is what I'm saying,
Well, there is
between what we have here and the exercise of discretion?
Well, I mean, yeah, there is a distinction. They are different, but what distinction are you getting at?
But you're saying it's a distinction without a difference.
Certainly, I mean, the hard 50 is within the sentencing range, and it's not a mandatory minimum because the judge has the discretion after he finds the facts to weigh them, and that weighing process provides the guided discretion that the court was talking about because it's not an absolute mandatory minimum, as was the case in Elaine.
Any further questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
Justice Lukert, I just wanted to answer your question on ripeness because I've been thinking about that since October. And I certainly think this is ripe. A case is unripe if it's hypothetical or abstract. But you have before you right now very concrete arguments regarding retroactivity or the ability to apply this amended statute retroactively between the parties. So you have a very concrete formed dispute between the parties. And appellate courts have to decide remedies among disputes sometimes. So that's justiciable for this court. And there are no facts that need to be found. It's purely a legal issue. So I think that this issue of retroactivity or non-retroactivity is ripe. It's before this court and should be decided by the court as soon as possible.
And you think that's true even though we don't know if a jury on remand under the new law would apply a hard 50?
I think that's true. You obviously in any number of situations don't know what a jury will do on a remand, but that doesn't prevent you from deciding what the right remedy is as far as the remand. I mean, like, on a sufficiency case, what's the remedy? I don't think we would say we don't have to decide, we'll just send it back for a new trial because maybe he won't get convicted next time. No, there's an answer to what's the correct remedy for the appellate court. And that remedy affects the legal rights of the parties. Right now, the decision you would make regarding remedy will affect the rights. Will Mr. Astorga have to go through another trial? Will the state have to go through another trial? Will he be entitled to a final judgment? You would be resolving those rights. It's not abstract. They're real rights for real people right now.
And is there sufficient evidence of the prior conviction in the record for us to consider that as a potential remedy? Do you know, did your client stipulate to the criminal history?
It wasn't contested. I don't know if he stipulated to it. I don't think those are the same thing, but we think for other legal reasons that that's not the appropriate remedy.
Any further questions? Any further presentation? Thank you, counsel. We thank both of you for your arguments this morning. Court will take this matter under advisement. We now turn